Well, good morning, everyone. On behalf of the Gunster Law Firm, I want to welcome all of you to the latest in the series of webinars that we have been putting on for our clients and friends of the firm related to the COVID-19 pandemic. My name is Joe Santoro. I am the chair of the Labor and Employment Group here at the Gunster Firm, and we are going to be talking today about what employers need to do in order to prepare the workplace for employees to return. I'm joined today by two of my colleagues, my law partner, Joe Jaco, and my colleague, Anthony Nelson. We have been getting what precipitated our webinar today is we've been getting a lot of questions from our clients about the issues relating to employees coming back, employees requesting accommodations, and of course, the more recent questions relating to the vaccine and employers and whether or not employers need to mandate the use of the vaccine or do it on a discretionary basis and what the issues are relating to that. So we are going to talk a little bit about all of those topics and a couple of housekeeping matters that I want to address before I turn it over to Joe Jaco. First, we are recording the webinar. You can view a replay on demand starting tomorrow by visiting the videos and webinar section of our gunster.com website. Feel free to share it with others. Additionally, you can find other timely information on our COVID-19 resources and insights page. I would encourage all of you to submit any questions you may have using the Q&A feature on your screen. Questions are going to be sorted and read aloud anonymously. We won't identify where the questions are coming from. And we have a limited amount of time and a very busy agenda. So we will try to reach as many of those questions as we can live. And in the event we do not get to your question during the live portion of this presentation, one of the Gunster lawyers participating in the webinar will follow up with you and try to get you an answer to your question as timely as we can do that. With all of that being said, I wanted to turn it over initially to my partner, Joe Jaco. A lot of you may know Joe Jaco as the former general counsel to the Florida Governor, Ron DeSantis, and he was responsible for authoring the executive orders for the governor during his tenure. He's going to be providing some insight on Florida's response to COVID, particularly as it relates to the vaccine availabilities, and we'll also talk a little bit about the limitations on liability waivers that are pending both on the federal and state level. So welcome, Joe.
Hey, thanks, Joe. And thanks all to you for joining us today. I am Joe Jaco. I was the general counsel to the governor from the start of his administration until just a few weeks ago when I started with Gunster. In that role as the governor's general counsel, I oversaw all of the legal work, not just for the governor, but also for all of our state agencies that report up to the governor. So whether it's Department of Environment or the Department of Health or ACA, I oversaw the litigation and any of the regulatory work at those agencies. So as Joe had mentioned, I was responsible for drafting the governor's executive orders related to COVID, but in addition, I was responsible for ensuring that all of the state agency executive orders related to COVID were also legally sound. So what I wanted to do today is, with that background, just give you first an update on the vaccine distribution, where we are today, and then I'll go into some information on COVID liability, both at the state level and at the federal level. So yesterday was fairly historic for Florida as we had our first vaccine administered. We're going to get 179,000 vaccines from Pfizer in this first wave in Florida, and those are going to be going to long-term care facilities, so approximately 80,000 of those, and also to healthcare workers, and that's another 97,000. Also, the governor's announced that Moderna looks like it is going to come up for FDA approval on its vaccine this Friday. And if that's approved, then Florida could get another 365,000 vaccine doses. in addition to that, Johnson & Johnson has a vaccine. And what's important about this vaccine is it's only a 1-dose one as opposed to the others being 2 doses. That comes up for FDA approval in January. And they have already been manufacturing that vaccine and storing it. So hopefully we'll see that coming out early next year. With all of that, the governor said recently that he can see the vaccine going to the general population as early as February. And I know that the federal government's Operation Warp Speed plans to get out 300 million vaccines. So hopefully we'll see that timeline not only be met, but hopefully we'll see it be expedited as approval and production goes forward. All right, let me shift gears now to giving a little bit on COVID liability. From the start of the governor's executive orders in March, we had a mindset that from the state level, we would look to mostly protect individuals, and there are certain emergency powers the state has that allows for that kind of authority related to individuals. And we'd allow local government to use their own authorities, which is in the building codes and in other safety codes, to regulate venues, obviously buildings and business. In that first significant and only for Florida stay-at-home order throughout the month of April, that's the process we took. So, we deemed certain businesses that were essential. Those mostly came from a federal list at the Department of Homeland Security, and we had individuals stay at home. Now, one important feature in that, and this will play out some in the way that the governor thinks through COVID liability, is while we had individuals who weren't working at those essential businesses stay at home, we did not shut down business wholesale across the state. So for instance, we've got a local bookstore here in Jacksonville where I live, and the owner moved her bookkeeping inventory, what she uses just for accounting purposes, online in a way that allowed customers to access it. And she said, look, if you buy a book during the month of April, I'll give you a 50% discount. And when I can open my doors again, you can come pick it up. That's exactly the kind of thing that we want, is to keep business open in spite of the fact that we're taking efforts, I was taking efforts on behalf of the governor to protect individuals. So with that in mind, the state has moved through several phases in reopening and got to that phase 3 reopening, which from at least the state level is back to normal, although there obviously are certain local regulations that are still in place, including obviously mask wearing in some cities. With that phase 3 reopening, we also this past fall saw our first lawsuit based on COVID. This was a lawsuit that was filed by a grocery worker in South Florida who claimed that his employer's mask policy led him to contracting COVID. Now, this was COVID that he contracted back in March when guidance was still evolving, and we'll see what happens as that suit proceeds. There's another lawsuit that's in the Tampa Bay area of a restaurant patron who went into a restaurant, saw that people weren't wearing masks, claims as a result he suffered emotional distress, and now has filed a lawsuit for $1 million. So these are the kinds of lawsuits that we're just beginning to see and that we're going to see more of. So let me talk about what the state has done in forming what is referred to as the Reset Task Force to look at COVID liability. And this task force has looked at legislation in other states, in Alabama, and New Jersey, and Kentucky, and Tennessee as models, and has 3 main points for addressing COVID liability. The first of those is creating a limited cause of action for COVID liability for someone who's been potentially exposed to COVID that has first a higher culpability standard than normal negligence. So this would be a gross negligence standard or an intentional standard. And this really raises the bar for someone to not just allege that they possibly contracted COVID from a particular business, but they really have to assert, and the court has to determine that it was likely the person got it from the business. In other words, that the business would have acted in some way that was potentially reckless for that person to have contracted COVID. So that's the higher culpability standard. The second piece of this legislation would be a higher evidence standard. And in this case, it essentially raises the bar to just more likely than not, the person contracted COVID from the business to a standard where there's got to be actual credible evidence, something that establishes a firm belief that the allegations are true against the business. The third piece, in addition to that higher culpability and higher evidentiary standard, is an extended statute of, a shortened statute of limitations for someone filing a lawsuit only within a year of that exposure. And in addition to that, a provision that would, for any business that was essential, so businesses that were open during that stay-at-home order and going forward, that they are exempt from liability. And that's a critical piece to this, because these are companies that, on behalf of society, the government, continued to do business even as that kind of CDC guidance was evolving in terms of the requirements. This legislation has been supported by the governor, by the CFO, by the House and Senate leadership. So, I expect that we'll certainly see plenty of discussion and debate on it as we go into the legislative session, which this year will begin in March. Committee hearings will start earlier in several months before. All right, let me quickly hit federal efforts. There's a spending bill, a $1.4 trillion spending bill that expires at midnight on Friday. So, our House and Senate members have been working towards putting in COVID liability reform into this, along with other provisions such as unemployment benefits. It's probably going to be announced today that COVID liability is not going to be in this package that will be passed. And certainly it's a big motivation for our congressmen and women and senators to bring something home to their constituents if they're going to head home for the holidays. So that liability piece will probably be broken off, and it'll be tied to some funding that would go to state and local governments. And that would be kind of a deal that would be left to fight for another day. On the federal level, that liability provision, if indeed it's taken up later, would have the same kind of heightened gross negligence, heightened clear and convincing evidence standard, same statute of limitation. But what's important about the federal legislation is it would preempt any state causes of action. Now, if a state wants to do more, wants to provide more protections, more liability, they're welcome to do that. But otherwise, the federal legislation would move all of those cases to federal court. This would go into effect, and it would be in effect for approximately 4 years, and then ultimately have a sunset. So let me right there just kind of leave it at that for the update. You'll certainly be seeing more in the news today in terms of what Congress is doing, and obviously more in terms of the vaccine rolling out. But I'm happy to answer questions in our Q&A period. And right now I'll send it back to Joe Santora.
Thank you very much, Joe. Obviously, our clients are all very interested in the liability waivers and limitations associated with that legislation. It's going to be very important for businesses to be able to have some comfort in reopening, both in having some protection for liability from both their employees and also from their customers. So we're looking forward to seeing what the governor does on that, and thank you for giving us that update. Well, here we are. I know that over the summer, there was a lot of talk, particularly from the president, about having a vaccine ready for distribution before the end of the year. The president was widely criticized for making those bold statements about the production of this vaccine, and it looks like it's turned out to be true. It is a monumental effort, not just by our federal government, but also by all of the private industries that have made this happen through their efforts in research and development of these vaccines. So like all of you, most employers are now looking towards the future. And the very first question that we get asked, and it was actually the first question we got in our webinar today, is, well, now that there's a vaccine available, as an employer, am I allowed to mandate that my employees take that vaccine? And it is a complicated question, one that we're going to answer today. And the short answer to that question is yes, that under the current guidance from the EEOC, there is nothing that prohibits an employer under the appropriate circumstances to mandate that their employees receive the vaccine in order to continue to work or to be hired. However, the real answer to that question is it depends. And the reason why I'm qualifying that is because if you do mandate the vaccine, you have to be prepared to make exceptions to that mandate for individuals who have disabilities that qualify as disabilities under the Americans with Disabilities Act and state law, as well as to accommodate individuals who have a sincerely held religious belief under Title VII that would prohibit them, without violating their religious beliefs, from taking the vaccine. So there is risk associated with mandating that your employees take the vaccine. And that risk, and the reason why I say it depends, really is just and we'll get into the details on this, but really it's just going to be a balance for you as an employer, whether or not undertaking that mandate is worth it in light of the risks associated with having to deal with those accommodation requests and the potential exposure that you might have for disciplining or terminating an employee for refusing the vaccine for one reason or another. This is not new. We have had industries where vaccines have been mandated for a long time. They're mandated in schools. They're mandated in healthcare, certain healthcare providers. They're mandated in nursing homes. What's new is that we're going to be seeing vaccines like this being used for the first time in business settings and office environments and manufacturing settings where it's never been done before. And for those of you who are employers that have no experience with dealing with vaccine-related issues and dealing with the requirements of the law for accommodating people who don't want to take the vaccine for one reason or another, it's going to be a challenge, and not one that we would recommend you engage in without, gratuitous statement here, without the assistance of your counsel, because these are very technical things that you have to do correctly in order to avoid getting sued. There will be, unlike ever before, in light of where we are in 2020, there will be tremendous pressure on all of you and your businesses to mandate this vaccine in the workplace. What do I mean by that? Well, just think of it from a pure economic standpoint. If you are in the hotel industry, if you are in the service industry, if you are in the restaurant industry, are you going to be the one employer who, when all of the other companies are mandating vaccine and are promoting it and advertising their business as being a safe business because their employees are all vaccinated, are you going to be an employer who doesn't do that and goes against the tide there? You're going to get tremendous pressure from your employees. who are fearful of this virus, who don't want to return to work, and who are going to pressure you as an employer to not only make it available, but also to mandate that all of their coworkers take the vaccine. And I suspect, although this is perhaps a bit cynical, that there's going to come a time where there's going to be some governmental pressure on your business to require your employees to take the vaccine. Now, no one has come out and said that yet, but I don't think it's a stretch. If you look at what is happening in some major, cities like New York and Chicago and several other places around the country where they're imposing very severe restrictions on businesses being open, I don't think it's a stretch that maybe someday you might see some local government direction that says if you want to have your bar open, you have to have your employees vaccinated. Now, I question whether there's legal support or authority for a government entity to do that, but hey, nothing is stopping them from doing what they're doing now. So there will be some likely pressure from state and local governments to push the vaccine on employers. I don't think we'll see that here because we have a very tremendous governor in the state of Florida, in my opinion, who's been very level-headed when it comes to imposing those types of restrictions on employers, but we'll see. You're also going to have some opposition to that. You're going to have, I know many of you have had people who opposed wearing the masks for various reasons, ranging from, I can't breathe, to political objections, to numerous other things as to why they didn't want to wear masks. You're going to have people who are, the term is used, anti-vaxxers, who believe that vaccinations are bad. And, we've seen that in the space relating to, parents who don't want to have their children vaccinated because of, side effects from those vaccines. So you're going to have, as an employer, you're going to have a lot of pressure on both sides to make this decision about whether to mandate the vaccine or not. The word of caution here is don't do it lightly. Don't make a knee-jerk decision about this. Think it through. Think about the implications to your business and whether or not you are prepared to deal with the ramifications of making that decision in an affirmative way. So the next question is if I decide to mandate the vaccine, how do I do it legally? And we talked a little bit about this. There are certain industries where it will make a lot of sense to mandate the vaccine. And we've seen and heard anecdotally from clients and from industry experts that we are in contact with, as well as our contacts within the government, that there are a number of industries, particularly manufacturing, where employers are already saying we are going to mandate this. And the reason that they're going to mandate it is because there is a substantial risk due to the nature of the business that they operate to both coworkers and the general public. If you're in the service industry and you send people out into people's homes, well, there's risk involved in doing that. And so those employers are leaning towards mandating the vaccine. If you're on an assembly line and you can't socially distance between you and the worker next to you, there is risk associated with not mandating the vaccine. So there will be, I think that's very different, however, than an office setting where all the things that we've been doing thus far are alternatives to having a mandated vaccine, and maybe a different approach, and adopting and continuing to maintain those things may be a different approach than mandating. So if you do decide to mandate the vaccine, you have to be prepared to deal with the accommodation request. And the first one is under the Americans with Disabilities Act. I know most of you already know what is required under the ADA, but generally speaking, the ADA requires that if you have employees who have disabilities, qualified disabilities under the ADA, you as an employer have an obligation to provide reasonable accommodations to those employees who, because of those disabilities, can't perform the essential functions of the job, or in this case, because of those disabilities and the side effects from the vaccines, are not able to take the vaccine. Well, how do you know that? Well, the truth is, you're not going to know that, right? What is more likely to occur is you're going to get an employee who comes to you and says, hey, I have a respiratory illness, I can't take the vaccine, or they're going to come to you with a note from their doctor saying, hey, my doctor told me I can't take the vaccine. And how are you, as an employer that doesn't, know medicine and doesn't have a complete and full understanding of the side effects of these vaccines and how they impact people with those types of disabilities, how are you going to evaluate the reasonableness of that employee's request? It's going to be very challenging. So the first thing that you're going to have to do is, if you get those requests from an employee, is go to what we're already doing. Look at, are there alternatives for that employee that will enable them to be able to do their job, such as, everything we've done before, working from home, mask requirements, barrier requirements, split shifts, other types of prophylactic measures that can protect not only the employee who remains unvaccinated, but others in the workplace. Are there things that can be done short of taking the vaccine? A good resource for you, if you don't already know about this, the JAN Accommodation Network, there's a website called askjan.org where you can go in, and it's not completely updated for COVID, but you can go into that and click on, what the employee's condition is, and it'll tell you what types of impacts that disability might have, and even offer some suggestions on how to accommodate it. So if you're looking for ideas as alternatives, that's a good resource. So let's say you get through all that and there isn't an accommodation that you can figure out for the employee because of the nature of their job. When can you say no? And when can you discipline or terminate an employee because they refuse to get the vaccine? The answer is, under the ADA, it can be difficult. There are two circumstances where you can deny an accommodation under the ADA. And the first is where the requested accommodation poses an undue hardship on the employer. And under the ADA, there's lots of case law on this, but really you have to have what they call a substantial operational difficulty or substantial expense to the employer. And I will tell you, in other contexts, that is a very, very high burden to reach. The bigger of a company you are, the less likely that type of undue hardship argument is going to work when denying an individual an accommodation to not take the vaccine. Where we think the battleground is going to be on this is in the second exception. And the second exception is where the individual, because of their unwillingness to take the vaccine, poses what they call a direct threat to either their coworkers, themselves, or the general public. The direct threat is going to be the issue. And we have been in contact with the EEOC, offering our views on this as they develop their own guidance. By the way, it may come out as we are speaking during this webinar. It has been in process, we understand. There's been a push to get that guidance out. We think that a lot of that guidance is going to deal with this issue of direct threat and whether employers can deny accommodations due to a direct threat. The reason why we feel that way is because the EEOC has already spoken on this topic when the CDC classified COVID-19 as a pandemic and essentially relaxed and suspended some of the limitations on an employer's ability to ask medical questions under the ADA because we were in the middle of a pandemic. So we think we're waiting on that guidance. Depending upon what it shows, we feel like we've got a pretty good idea of what it's going to say. But we think that employers will be able to deny accommodation requests for employees that don't want to take the vaccine if they are able to show that because of the job that they do and the industry that they are in, failing to get that vaccine creates a threat to others. And that's where the rubber's going to meet the road in this analysis. But you're not done. Before you can fire an employee, of course, for failing to take the vaccine, you have to go through all of the other accommodation issues and see whether there's an alternative to allow the employee to do their job, like I mentioned before. Is there something else short of not hiring the employee or terminating the employee that can be done to let them do their job? So that's the ADA issue. Look for the guidance on direct threat. We feel pretty confident that what we're telling you is going to be consistent with what the EEOC is going to issue shortly. The second area that you're going to have to accommodate, and this one is perhaps a little bit trickier, is the religious accommodation. So Title VII of the Civil Rights Act requires that employers accommodate an employee's, quote, sincerely held religious beliefs when making workplace accommodations, unless, like the ADA, the requested accommodation poses an undue hardship on the employer. Let's talk about those separately. What is a sincerely held religious belief? Well, the first one, and it may sound rather obvious, is that the employee's objection has to be religious in nature, meaning that what they are complaining about or their refusal to take the vaccine has to be because they have a religious belief. A simple objection to taking vaccines, even if it's sincerely held, or because the employee believes in a holistic lifestyle. Sorry for those of you that are out in California, you'll probably be dealing with this maybe a little bit more than some of us in Florida, but employees who just have an aversion to vaccines or believe in organically treating their health and don't want to take the vaccines, that's not going to cut it. It has to be a religious objection. And there's a case decided earlier this year. It's Brown versus Children's Hospital of Philadelphia, which makes that point. So we feel pretty comfortable that we'll be able to draw that line in the sand when it comes to accommodating religious beliefs. Then you have to decide, well, is the employee's belief a sincere belief? And that's a challenging one. And for those of you that have never dealt with religious accommodations in the workplace, what you're not allowed to do is test the validity of the religious doctrine. Meaning you can't say to someone, hey, I know Judaism, I know Christianity, and I don't see anything in the doctrines of Judaism or Christianity that says you can't take a vaccine. You can't challenge an employee on the doctrine. Where you can challenge them is on whether or not they have a sincere belief that their religious canons are violated by taking the vaccine. So how do you test that? Well, one way would be to ask the employee if they've taken other vaccines. If the employee takes a flu shot every year, then it might be difficult for them to establish that they have a sincere religious objection to taking the COVID vaccine. If they've taken other vaccines, then perhaps you may be able to make the argument that the employee doesn't have a sincere belief. One word of caution here, and something I'm seeing out there on the internet, maybe it's more conspiracy theory than it is legitimate, but there are some people who are starting to object to taking the vaccine based on the fact that some of them, and I don't know this to be true, but I'm seeing this in the buzz, are either tested or using stem cells in their development or in their production. So you might get some people who have a belief that the use of embryonic stem cells violates their religious canons, and because of that, this vaccine, unlike others, would violate their sincere religious beliefs, and therefore you would have to accommodate that. There is, however, as I mentioned, another exception, and that is the undue hardship exception. Now, what's different about this in the religious context is that the standard for an undue hardship is considerably lower than the standard for an undue hardship exception under the ADA. Under the ADA, as I told you before, remember, it's substantial operational difficulties or expenses. For religious accommodations under Title VII, the standard is it has to have more than a minimal burden on the operations of the business. So it's a much lower bar to deny a religious accommodation based on undue hardship than it is an accommodation under the ADA. So let's say you go through all that, and now you've decided to mandate the vaccine, and you're going to require all your employees to have it. How do you effectively do that? Well, assuming the vaccine is available, some employers are even talking about doing it in the same way that flu shots are done, where they arrange for it, they have someone come to their facility, they give the vaccine out at their facility, and it's done. Be careful about that, because if you start doing that in the workplace as opposed to just letting your employee go out and get the vaccine and provide proof to you, you might run into problems under the ADA about whether or not engaging in that process constitutes an impermissible medical examination. Under the ADA, you can't conduct medical exams unless it's consistent with a business necessity or there's a direct threat issue. What I will tell you is that the administration of the vaccine, in my opinion, and the opinion of our legal team here at Gunster, is not a medical inquiry. Now, you're going to hear lawyers tell you otherwise. There are some lawyers out there that think it is. I suspect the EEOC will clear up this issue in its guidance, but simply, administering the vaccine or mandating that an employee get the vaccine and provide you proof that they've had it is not going to be a medical inquiry, because all you're asking for is, do you have the vaccine? Now, where you can run into trouble on that is if you're doing the administering in your workplace or using a third party to do it, before people get the vaccine, questions get asked, about side effects and conditions. And when you start getting into asking an employee about medical conditions or potential side effects that might be triggered by the vaccine, you can then fall into that becoming a medical exam, which is why our recommendation is to be very careful about taking on the obligation of doing this in-house for your employees. Some other considerations, hopefully that will be addressed by, and this may get a little bit technical, but some other considerations is GINA, the Genetic Information Non-Discrimination Act, and whether or not mandating a vaccine or requiring an employee to provide proof of a vaccine would violate GINA. We think the answer to that question is no, because you are not making a decision based on genetic information. You're basing a decision based on whether that employee is vaccinated or not without delving into the whys. We hope that the EEOC, and we expect that they will, issue some guidance on GINA. The last thing I'm going to mention before I turn it over to Anthony is OSHA. And OSHA is an area where we are a little concerned because OSHA's views on and interpretations relating to mandating vaccine, we think creates an opportunity for there to be problems for employers that mandate it. Specifically back in 2009, when the H1N1 vaccine was out, they issued an interpretation letter stating that it's not prohibited or required by OSHA for employers to mandate the H1N1 vaccine. However, if an employee objects, and this is in their opinion letter, if an employee objects to taking it or refuses it based upon a, quote, reasonable belief that he or she might have a medical condition that might be harmful to them if they take it, that employee would get whistleblower protection under OSHA. So there's a bit of an inconsistency with what we think is coming from the EEOC about mandating vaccines and whether or not you can terminate an employee for failing to take it, and what OSHA has said in its 2009 guidance. So we're watching that one closely. We think it will be cleared up, but as it stands right now, that is an open issue. So we will answer any questions that you may have about that at the end of the presentation today. Right now, I want to turn it over to my colleague, Anthony Nelson, who's a member of our employment group, who's going to talk to the group about the other issues that arise when you have an apprehensive employee who doesn't want to come back to work. separate and apart from those related to the vaccine. Anthony?
Thanks, Joe. As Joe mentioned now, we'll get into the main topic for today's webinar, dealing with an apprehensive workforce, including how to handle, COVID-related requests for accommodations. The goal for today is we really just want to give you guys very, very practical guidance that you can take from this webinar and you can apply when certain issues arise, if at all, that you'll see in the future. But the areas that we're going to cover today, I'm just going to give you a quick list of, do's and don'ts to keep in mind. And then after that, although Joe touched on it a little bit, we'll run through some of the general requirements under the ADA in connection with providing a request for accommodation. And then lastly, we'll run through what we believe to be the most common scenarios that we're seeing pop up in the workforce and what are the best approaches for dealing with each of those scenarios. So turning to the quick list of do's and don'ts, if you haven't already, I assume most have, but if you haven't already, you want to make sure that you put together a response team and you draft and put together a return to work plan for employees that makes the necessary changes to the workplace that's based on CDC guidance, Osha guidance, and then you want to make sure that first, your managers and supervisors are trained on this return to work policy. That way it's properly implemented before employees start returning to the workplace. Before we even have our employees return to the workplace, it's critical to communicate with the employees about what exactly is in the return to work plan. This will really help, especially with the topic we're talking about today, alleviate certain concerns that a number of employees are having, right? Knowing that your employer is out there, being proactive, taking the necessary measures, and setting up the workplace in a way to protect employees will really help alleviate concerns and then possibly, prevent some lawsuits that could come about as a result. And then finally, the main thing for today is when dealing with an apprehensive workforce, any employee that has a general fear of coronavirus, we want to make sure that we fully understand that employee's circumstances before we just flat out reject a request for accommodation that's based on that employee's fears. Similarly, if you have an employee who refuses to return to the workplace because of health-related concerns or some other fear tied to the pandemic, we do not want to have a visceral response and just immediately pull the trigger and terminate that employee. Instead, we want to engage with that employee and take more of a soft approach. Right. So the short answer is this, right? The question we keep getting a lot from employers is, can an employee discipline an employee? Can an employer discipline an employee who refuses to return to the workplace because of general concerns or apprehensions, connected to the pandemic? The answer is yes. But is that the best approach is the real question. And we found that the best thing that employers can do when dealing with these employees is to take more of a soft hand approach and to engage with these employees, because it'll probably serve them better in the long run should this employee, decide to pursue litigation later down the line. But we'll get into that in much more detail in a little bit. Real fast, I know Joe touched on it, but we're going to walk through some of the general requirements under the ADA in connection with providing reasonable accommodations. One thing that we keep hearing from employers is whether or not they are required to provide telework if it's requested. Right? There's this growing misconception now that if my employer previously provided it to me, well, surely they can't take it away. Or if it was previously provided to me, if I simply just ask, well, then it should be honored. which just, is not necessarily the case. Under the ADA, the employer is required to provide a reasonable accommodation to qualified individuals in connection with the known disability. So in short, because of the disability, right? Now, the accommodation itself does not have to be telework. Even in the circumstances that we're currently going through with the pandemic, telework is not the only option, as Joe touched on. There's other things that can be offered when going through this interactive process. For instance, modifying work schedules, reducing hours or changing hours, or moving around an employee's schedule in a way to where they're performing certain functions at different hours when they're not in close proximity to others. Providing or allowing an employee to wear PPE in the workplace. Again, these are just some of the examples that are other options in addition to telework. Telework, of course, is still a reasonable accommodation if it can be provided, but it is not our only option. So that's one thing to really keep in mind. And then the other thing is, who's entitled to an accommodation, right? Under the ADA, it's a qualified individual with that known disability who's entitled to the reasonable accommodation. So put another way, it is because of the accommodation, not because, perhaps a loved one has a disability, or perhaps, a child's home from school and I need telework, or I have this general fear of, the pandemic. These aren't sufficient bases to warrant a reasonable accommodation under the ADA. So the question that we keep getting again is, well, what do I do with an employee who makes that request but isn't entitled to the accommodation? Should we write something to their file? Should we confer with them and go through the interactive process anyways, or should we just flat out terminate them? And again, the answer is, if it's not connected to the disability, and we'll go through different types of scenarios that you're likely to see, but if it is not connected with the disability, an employer does not have an obligation to provide does not have an obligation under the ADA to provide that accommodation if it's unrelated to the disability. But what are some of the scenarios where, despite that, an employer may want to take a different approach rather than just flat out rejecting a request for an accommodation? Again, the first scenario, and the most common one that we are seeing popping up, is these employees who have a general fear of the pandemic. Again, the short answer is a general fear or apprehension with the pandemic is not a basis in and of itself that warrants an accommodation. But again, taking this soft hand approach with the employee, it's crucial to follow up with an employee and fully understand their circumstances and their concerns. So for instance, take a thoughtful approach with employees and ask the employee, well, what are your concerns? Is there anything else that you believe can be implemented to help deal with what these concerns may be? And then also take a chance, as we talked about in the beginning, if you have that return to work plan in place and you've been taking all of the necessary measures to educate the employee on that, to remind them about all the measures that have been put in place to protect the employee and also to keep the workplace safe. The reason why you want to take this approach is because rather than just reacting and terminating, should this lead to litigation, you have to ask yourself, how would a jury respond to that? Yes, granted, under the law, you can, again, just terminate somebody who refuses to return to work just because of a general fear of the pandemic. However, remember, a lot of the people sitting in the jury may share in on some of those fears. They may be reluctant to be serving on jury duty that day because of their own fears with the pandemic. That's why it's crucial to, rather than just flat out rejecting or disciplining an employee, to instead taking the steps to hear that employee out, allow them to express their concerns, taking the opportunity again to re-educate them, and then at that point, seeing if they'll change their position. If they won't change their position, then perhaps taking another chance and stressing to them, again, going through the same process, reminding them of everything that's been done, and telling them that the opportunity is there. And at that point, if an employee still refuses to return, well, now you can mark that down as the employee electing to abandon their job rather than you being the one to terminate that employee. Again, later down the line, this will better serve employers because you'll be able to say, we knew what our obligations were under the ADA. We followed all those obligations. We went beyond those and tried to do everything we could for this employee to address their concerns, despite not having to. But at the end of the day, the employee elected to abandon their job. So that's a theme you're going to hear me, continue to touch on as we go through some of these other scenarios. But that's the main one that we continue to hear. Again, the short answer is you can terminate employees who refuse to return to the workplace because of a general fear, and they are not entitled to an accommodation. Nonetheless, it's worth the time to go through that process and to hear that employee out. The next scenario that we're starting to see pop up a lot is, well, what about age? We've heard there's a connection between those that are 65 and over and being part of that vulnerable population and having, being more susceptible to the pandemic. Age in and of itself under the ADA is not a basis for an accommodation. Again, put simply, a qualified employee with a known disability is entitled to an accommodation, barring undue hardship, as Joe previously mentioned. But age in and of itself is not. But again, sticking with our same theme, if an employee who is over a certain age is in that population of 65 or older, you're not required to provide the accommodation, but the company can, if it wishes to, choose to find an accommodation to provide these employees. But what's important is you want to make sure that you don't run afoul of some of the other anti-discrimination laws. So specifically here with age, we can't now, as a result, start to treat our older employees differently and start to mandate, for instance, that they actually stay home, because we feel that we're actually looking out for their best interest and trying to protect them. You could find yourself in a sticky situation because you are treating that group of employees different than everybody else based on their age in that situation. So while you can't mandate that they do stuff, you have to provide them the same opportunities to return to the workplace, just like you are all other employees. The next one, medical conditions. We're starting to see a lot of employers saying which medical conditions, given the pandemic, would warrant an accommodation. Well, at this point, those of you that are familiar with the interactive process, this is the scenario where you want to engage with that employee and go through the interactive process. If the employee's medical condition is unknown, well, the employer can push in further and try to solicit more information or request more information regarding, the severity, the nature of this medical condition to determine, whether or not, this individual is entitled to an accommodation under the ADA. If you're still not getting all the information that you need, for instance, the employee just says, I have a general underlying health condition, again, you can work and go back and forth with the employee and continue to request additional information until you have the information that you need, to move forward. And then, just like with our other employees who have these general fears and apprehensions with the pandemic, it's critical here to, while going through the interactive process with those that have a medical condition, regardless of whether it is to be open to, different ideas that can possibly be implemented to help deal with, these purported medical conditions. Again, telework is not our only option. There's other options that employers can elect to implement. The next scenario, loved ones, family members that an employee is caring for at home. And that loved one has an underlying medical condition, or perhaps has a disability that falls squarely within the definition of the ADA. What if those employees say they're concerned because I could possibly contract coronavirus in the workplace and then bring it home to my loved one who is, in a very vulnerable state? This scenario is not a sufficient basis for providing an accommodation. So the answer there is, like our general fear, employers are not required to provide an accommodation in that setting. However, what's important in this specific scenario when dealing with the employee whose claim is, to be caring for a loved one, although that employee is not entitled to an accommodation under the ADA, they may be entitled to leave under the FMLA to care for that individual. So at that point, you just want to make sure that, again, when you're talking with employees, you're fully understanding the circumstances of their request. That way you can properly address their concerns. And then, for instance, in this scenario, make sure that that employee the opportunity to seek leave under the FMLA. And then,
Anthony, I'm sorry to interrupt you. I just want to let everyone know that we are running just about out of time here, but we are going to extend our presentation for about 5 or 10 minutes longer to get to some of the questions that are pending in our inbox. Just sorry to interrupt you, Anthony.
No problem. No problem. And the last two scenarios, the one that we saw pop up very early in the fall and is likely to pop up again even more so come the turn of the new year is children that are learning at home or remote learning. Again, we saw this pop up early on in the pandemic, and employers need to be aware that in this situation, again, that in and of itself is not a basis for an accommodation under the ADA. However, that employee, just like with our FMLA situation, could be eligible for leave under the Emergency Family Medical Leave and Expansion Act that was passed by Congress earlier this year. So if you are a covered employer, meaning you have fewer than 500 employees, and that employee has not previously used leave under the new Family Medical Leave Expansion Act, you want to make sure that that employee is provided that opportunity despite that they're not entitled to an accommodation under the ADA. And then the last one to keep in mind is that employee who says, which is slightly different than having a general concern or fear of the pandemic, instead claims that the workplace is itself unsafe. As Joe touched on earlier, under Osha, employers have an obligation to provide a safe workplace. So in those situations, you want to make sure that just like our employees who have a general fear, we want to be thoughtful. We want to engage with this employee and ask them for more follow-up information of what specifically they believe to be unsafe about the workplace, what suggestions they may have, because any sort of adverse action against this employee can very quickly turn into a whistleblower claim or a retaliation claim that you would later have to deal with. So with that, we'll jump into questions now. I know I'm seeing here on my end, Joe, it looks like we have a number of questions on the vaccine. So I'll turn it back over to you.
Okay, thank you, Anthony. Let's jump into a few of these. We're going to run 5 minutes longer, just try to get to a few questions. And as I mentioned before, if we don't get to your question during the live section, we will, somebody from our group will respond. So the first question that I'm seeing really relates to the direct threat issue. A person writes in, I understand that the vaccine doesn't prevent a person from getting COVID or spreading COVID, just allows the body to fight it off, similar to the flu shot. So how can the vaccine be mandated to protect others? If you can still catch it and spread it, the vaccine doesn't protect others, it only protects yourself. Well, that's partially correct. I mean, obviously, if you get the vaccine, then you're minimizing the opportunity that you would get the virus, but it's not 100%. First of all, it's not 100%. And even all the studies are showing that these are about 95% effective in preventing, getting symptoms from the virus. But if you're somebody who is for example, in the service industry, and you're going into people's homes, or you're having contact with the general public, then by you not having the vaccine, you are presenting a threat to those that you come in contact with, because you're more likely or you're more susceptible to getting the virus and spreading the virus. So that's what we're talking about when we talk about a direct threat. Another question we got, this one perhaps Anthony, you can answer. Based on the current status of the virus in Florida, Jacksonville, do you recommend employers with office environments mandate masks when we return in January? Anthony?
Given the current circumstances that we are in, it is probably the best practice to require that employees, when walking in the office, are wearing masks. Until the vaccine is widely disseminated, that is the best approach to take. And I see another question that's somewhat related to that. We saw a question come in that says, if an employee tests positive, can you require negative tests before they return to the workplace? And the EEOC has taken the position that, again, given the circumstances that we're in, an employee who was known to have tested positive for coronavirus previously would constitute a direct threat to the workplace, right? So you can require negative tests before employees come back, but you don't have to go and do just the test. You can also do other measures like temperature testing and things like that as well. But one thing to keep in mind is the EEOC has been very strict about which types of tests employers are using or requiring if they're the ones that are doing the testing in the workplace.
Thank you, Anthony. Joe, Jaco, here's one that maybe you can answer. I think it falls into the issue of liability limitations. If a business does not choose to mandate employees get the vaccine, can a current employee sue somehow for being forced to work in an unsafe environment or for being forced to leave the company? Any thoughts on that, Joe?
Yeah, no, I mean, that's somewhat the issue with the case that I mentioned arising out of South Florida, where a grocery worker said that his employer wasn't mandating masks, or at least maybe there was some confusion as the CDC guidance was evolving there. And as a result, he claims he contracted COVID. So I do think that that is one that is up for potential liability and a justification for getting that kind of protection in place at the state or federal level.
Yeah, and obviously the follow-up to that, Joe, is, does the workers' comp law currently as written contemplate this, if you know, and do you think workers' comp would come into play here?
Yeah, I don't know on the answer with workers' comp. I do know that under the federal and state legislation, workers' comp is not preempted in any way. So whatever the normal answer to workers' comp would continue to apply even if we do get some COVID liability protection.
Thank you, Joe. Anthony, this one I think would be good for you. The question is, will getting the vaccine give the person a waiver from wearing a mask?
So there, what's most important, right, is whatever policy that you as the employer decide to implement. What's really important is just to make sure that we're following that policy and that we're consistent with it. So if the policy is that, for the time being, when in the office you're required to wear a mask, then we want to make sure that we continue to follow that policy. Otherwise, should something happen, it could later be used against you that despite implementing it, the employer wasn't consistent with following it.
Thank you. And then the last question we'll answer during our live session, I'll try to answer it. The question is, what evidence or documentation must a person provide to show that they have a deeply held religious belief or a disability? How far can we go in asking follow-up questions of them? So I'll break this up into two pieces. Let's talk about it in the context of a disability. Remember that anytime you get an accommodation request, under the ADA, it has to be a request initiated by the employee. So if the employee comes to you and says, I can't take this vaccine because I have a condition that if I take it will result in me having negative side effects from taking the vaccine. So in that setting, you would be permitted to have a dialogue with that employee to talk to them about, well, okay, what's your condition? What are the side effects? How can we address those side effects in a different way? Can we do other things that will allow you to be able to do your job? You can make medical inquiries like that in that context as part of the interactive process under the ADA. I would suggest to you that before you go further and ask for any type of medical documentation, you should consult with your HR professionals or your legal counsel, because there are limitations on when you can go further and ask for documentation to support that. What I was suggesting earlier to you is that it's going to be tough to deal with that, because we don't really know entirely what the side effects of these vaccines are going to be and what conditions they are going to aggravate. We'll learn that as the vaccine gets rolled out a little bit more and the companies update their side effect guidance. So that's important. The second part about a sincerely held religious beliefs, it's kind of the same thing. You're not, as I mentioned before, you can ask if the employee objects to it on religious grounds. You can say, what's your religion and why do you object to this? What's your belief as to why you object to this? You can't go back to them and say, well, I know Judaism, and Judaism has nothing in it that says that you can't take a vaccine. You're not allowed to challenge the religious tenets behind that person's belief, only their sincerity in whether or not they're sincere in having that objection. And as I mentioned before, you can ask questions like, have you been vaccinated before? Do you take the flu shot? And if they answer, yes to those questions, it might give you some insight on whether that employee has a true, sincerely held religious belief. I'm not sure what kind of documentation you would ask for in the religious context. Probably, there probably isn't any. But before you go beyond the threshold inquiries, it would be important for you to get some legal advice, because you don't want to misstep there. So that is going to conclude our webinar for this morning. As I said before, thank you all for coming. We know these are important issues to you as you reopen your businesses and deal with these requests from the employees. And if we didn't get to your question during the live session, you can expect to receive an answer from us in short order. Thank you all for being here.
Thank you.